Well, the National Assembly has passed the Electoral Matters Amendment Bill yesterday. The bill seeks to change the funding formula of political parties and independents represented in the legislature to receive funding from government. The Council for the Advancement of the South African Constitution says it is concerned by the amendments to the political party funding regulation. For more on this, we are now joined by Lawson Naidoo, Executive Secretary at the Council for the Advancement of the South African Constitution. Lawson, good morning. Thank you so much for making time for us. So seeing that the bill has now been approved in the National Assembly, it's set to go to the National Council of Provinces, and some of the concerns that you have raised, which would you say are priority number one that needs to be dealt with?
Well, good morning, Aldrin. Thank you. I think we must start by saying that, this bill was necessitated because of the inclusion of independent candidates in the forthcoming national and provincial elections, and existing legislation needed to be amended to accommodate that. But what government and parliament have now done is to force through a series of very far-reaching measures that really undermines the Political Party Funding Act that was passed in 2018, which for the first time provided for transparency in the private funding of political parties. The effect of the amendments that were passed by the National Assembly yesterday is that it tears apart that transparency regime. It repeals both the thresholds and the ceilings that any single donor can provide to a political party. And it would mean that once this legislation comes into law, there will be no thresholds, there will be no requirement for political parties to disclose their donors. And the change of the formula in the allocation of funding, either from the public fiscus or from the multi-party democracy fund, is changed in favor of the larger parties. And we believe that this undermines the intention of the Political Party Funding Act and really, as I say, destroys any pretense at transparency. And we know, certainly from the evidence we've seen over the last few years, that there's a direct link between donations to political parties and corrupt practices in many respects.
Well, concerns that have also been raised by My Vote Count, and yesterday when I was speaking to them, they said that one of the biggest problems with the bill as well is that once the president signs it into law, it will effectively create a lull up until the elections where political parties and political players would be able to raise as much money as they want to, and there would be no obligation on them to actually disclose that money to the IEC because the act would essentially be repealed. This is the act requiring of political parties to disclose the 100,000 threshold donations that they've received.
Indeed, that is absolutely correct, and I think that demonstrates how the Party Funding Act has been totally dismantled through these amendments, because there would in fact be no thresholds or even a ceiling, so parties would not be limited to receiving 15 million from a single donor. But in the absence of any further promulgation of regulations to the Act, it would be a free-for-all. And as we come into these elections, the Constitutional Court has said that there's a direct link, and it's necessary for voters to have access to the private funding of political parties in order to be able to properly exercise the right to vote. And this undermines that and is therefore a crushing blow to democracy in South Africa on the cusp of these very important elections.
Yeah, another part to this bill as well is how the president will be able to determine what those thresholds would be, who's also, again, a political figure.
Yeah, and that is totally unacceptable. It would need to be done following a resolution of the National Assembly, but the president still has the authority, to refer it back if he's not happy with those thresholds. And there's, again, as we know, there's no time limit set for when the president needs to act to promulgate those regulations. So we're more than likely not going to see any regulations enforced before these elections in May of this year.
Ooh, so which means that we go into the elections and there will be no legislation that will require of political parties and independent candidates to disclose their funding. and who they get the funding from. But what about the aspect around how the money is dispersed from the IEC in terms of the 90-10 resolution, essentially, which has now been passed by the National Assembly?
Well, firstly, the last disclosures that were made by political parties was for the period ending December 2023. So that's the last information that we have available. With regards to the formula, it certainly favors bigger parties, and this was a huge issue when the Party Funding Act or bill was being processed through Parliament 5 or 6 years ago, and it was then changed from the 90-10 formula to a more equitable 2/3, 1/3 split, with 2/3 being allocated proportionately and 1/3 of the funding being allocated equitably amongst all represented political parties and now independent candidates. So it's certainly going to benefit the larger parties, in particular the ruling party, the ANC, but also the other big parties such as the Democratic Alliance and the EFF. And we note also that in the recent budget by the Minister of Finance, he's allocated an additional 200 million rands to the public funding of political parties. So, the bigger parties are certainly going to get a substantial boost in their financial coffers ahead of these elections. And that certainly doesn't speak to having a level playing field ahead of these elections.
Well, there's already an indication from some political parties that this bill, or once it is enacted, will end up in court. Is this something that CASAC will be supporting?
Well, I think we need to review the situation. As I said, the 90-10 formula was in place for many, many years until it was changed in 2018. And we would need to examine whether that formula of itself is unconstitutional. There is a provision in Section 236 of the Constitution that says that the allocation from the fiscus must be both proportional and equitable, but it's left up to Parliament to determine what the exact parameters of that formula, and we will have to look at whether this transgresses that or not. And it may well be that the courts will say that this is the discretion that the Constitution leaves to Parliament, and as long as there's an equitable component, even if it is only 10%, that it then meets constitutional muster. But that's something that may well end up before the courts, but certainly not before the elections.
Thank you so much for your time. That was Lawson Naidoo, Executive Secretary at the Council for the Advancement of the South African Constitution.